4, 3, 2. Good morning. We'll call the meeting to order. Police Policy Committee meeting on February 19th, 2026 at 10 a.m. Make the administrative announcement for the Police Policy Committee. This is a public meeting subject to public meeting law. It will be digitally recorded. Deliberation of issues will only be conducted by the Police Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to other persons in the room or makes it impossible to continue the meeting. I'll call for introductions.
When I call on you, please state your name and who you represent for the record. We'll start with you, Chair Nowning.
Scotty Nowning, non-management law enforcement.
Casey Cotting, Oregon State Police.
Member Sarek.
Nell Sarek, non-management law enforcement.
Member Daniel.
Mark Daniel, representing Oregon Association of Chiefs of Police.
Member Duncan.
Michelle Duncan, representing Oregon State Sheriff's Association.
And online we have Member Hensman.
Warren Hensman, representing the Oregon Association of Chiefs of Police.
Thank you. Member Livingston.
Teresa Livingston, Oregon State Police.
Member Loughran.
Patty Loughran, public member.
Thank you. And then Member Wood. Online as well.
Rob Wood, public member.
Thank you. And lastly,
Sam Willits, non-management law enforcement.
and now for staff introductions, Juan Lopez, Executive Assistant, DPSST.
Melissa Langacho, DPSST Professional Standards Case Coordinator.
Cindy Park, DPSST.
Jennifer Howell, DPSST.
Bill Castle, DPSST.
Maria Atwood, DPSST.
Sam Penny, DPSST.
Thank you. Has everyone had a chance to review the minutes from the previous meeting? Is there any requests for modifications? We'll be looking for a consensus to approve the minutes from the November meeting. Here's we have a consensus. No modifications? No objections? See none? Okay, we'll move on to administrative closures.
Melissa Langacho for the record. Chair and committee, the department completed a review of a professional standards case and is recommending administrative closure. The department is seeking a vote from the committee to approve or return the recommendation for additional information.
Thank you. Is there any, I think we only had one administrative closure. Is there any discussion regarding the administrative closure? Anyone have a recommendation that administrative closure be removed? Any questions, discussion? We're looking for a motion to approve the consent agenda as presented.
Mark Daniel, for the record, I move to approve the consent agenda.
Cotting, I'll second.
We're voting on a motion to approve the administrative closures consent agenda as presented. Chair Nowning.
Aye.
Vice Chair Cotting.
Aye.
Member Sarek.
Aye.
Member Daniel.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Loughran.
Aye.
Member Wood.
Aye.
And Member Williams.
Aye.
Motion.
Okay, moving on to the professional standards case reviews. I believe we only have one. They are not present.
They are not.
Correct? Okay. Go ahead. Thank you.
Good morning. Cindy Park for the record. We're here to review a case regarding Sabrina Whitaker. The department opened a professional standards case after we received a LEDS notification, and Ms. Whitaker was arrested on November 2nd, 2022 in Eugene, Oregon for DUII. On November 21st, 2022, Ms. Whitaker was formally charged with DUII, reckless driving, recklessly endangering vehicle involved, and driving uninsured. On March 2nd, 2023, Whitaker entered a deferred guilty plea disposition agreement for DUII The remaining charges were dismissed. On September 25th, 2024, the DUII was dismissed as Ms. Whitaker had completed all the conditions of her diversion agreement. Ms. Whitaker resigned her position from the Oregon State Police on March 31st, 2025. And I want to make a correction on the report under relevant relevant items. The date, if the committee recommends action in this case, the start date is actually March 31st, 2025, which is her date of resignation from employment rather than the April 4th, 2025, which was the date that the F4S form that we received was signed.
Thank you.
Mr. Denning.
We're looking for a consensus from the committee to adopt the record or return it to staff if additional information is needed. Anyone has any questions about that or questions for staff about additional information? If not, we're looking for a consensus to adopt the record. Any objections? Seeing none, confirm that the committee has recommended to adopt the record. We'll now discuss the aggravating and mitigating factors of this case for discussion. Remember to state your name and identify if your point is an aggravating or mitigating factor. And I think before we start, I think.
Oh, yeah. Conning, for the record, before we start, I will recuse in this matter just because my involvement in this investigation and awareness of her career and how it's gone.
Livingston, for the record, I would like to acknowledge that there could be a perceived conflict of interest due to the positions that I've held on the agency, but I didn't have anything to do with this investigation. And I feel that I can be fair and objective in my involvement in the vote today.
Thank you. So open up for discussion. I'll start. I mean, aggravating factor, Scotty Downing for the record, very high BAC, child in the car, caused an accident early in the morning. So, to be, and believe the below 0.4 several hours after drinking, her BAC was probably higher than that at some point. So, I think those are all aggravating factors.
Yeah, well, it's for the record. I'll add to that, to the aggravating. I think the fact that she told the other person that she questioned too that police aren't going to respond to this small matter is aggravating.
Over each other.
Michelle Duncan, for the record, aggravating, just that it was clear from the investigation that criminal investigation that she not only tried to be deceitful in trying to make sure the cops didn't show up at all. She also used her position to try and lend some credibility to the victim of why that would be the case. I think, I agree with everything else. It seems like a pretty easy case to me.
Yeah. Scotty Downing for the record, another aggravating during the field sobriety test. She's clearly intentionally messing with the most accurate of the tests, which is HGN. She's not holding her head still, even telling the officer, oh, I know how to do this. I do this all the time. And doing one of the tricks that other folks do to just not do the test correctly, not give the officer an opportunity to look at her eyes, which part she can't control. So, and I just think there was that kind of manipulation. Also refusing the test, which is by consent, had the officer write a warrant. So I believe that's aggravating as well. Scotty Downing for the record, if I didn't say that. Sorry. Anyone else? Any mitigating factors?
Warren Hensman, for the record, I think a mitigating factor would be her time on SWAT, specifically as a sniper. I think that has to be recognized for a pretty intense position over several years.
Livingston, for the record, I'm not aware. Is that in the record here? I don't.
Connie, I can speak to that, just to clarify the record. She was a part of the SWAT team for the state police, and she held a medic position.
Yes. Was not a sniper position. I wanted to clarify.
Thank you for the clarification.
Thank you for that clarification. I thought I read that it was a sniper position on the record submitted.
There's not anything else. I'll ask the case manager to review the aggravating and mitigating factors. We've got more.
Cindy Park, for the record, I have her mitigating the time on the job, specifically the SWAT and medic. Aggravating was a high BAC. There was a child in the car. It involved an accident. The BAC was very high and early in the morning, BAC being approximately 0.24. She told the other person involved in the accident that the police won't respond to small matters. She tried to be deceitful to stop the police from showing up at all in regards to the accident. She used her position to try to make that happen. She was intentionally manipulating the field sobriety tests and refused an initial breath test that ultimately required a warrant. That's what I've gotten.
Thank you.
Livingston, for the record. Can I add an aggravating?
Of course.
Because I don't think it was pointed out, and I think I read in here that she, her comments that she drank last at 9 p.m. and just understanding the way alcohol dissipation works, she would not be added to for at that time in the morning if she stopped drinking at 9 p.m. the night before.
Thank you. Anything else? If not, we're going to call for a consensus on the identified aggravating and mitigating factors. Member Wood? You frozen? Oh. We're looking for a consensus on that aggravating and mitigating factors. Any objections?
No objections.
Okay. We'll now open the discussion about the moral fitness violation categories. Reminder, the following options for moral fitness categories identified in the staff report. We can affirm, accept them as they are, modify, make changes, or negate, remove all. And in this case, all three: dishonesty, misuse of authority, and misconduct were identified. So we would be looking for discussion about those three.
Michelle Duncan, for the record, I think all three are appropriate in this case.
Mark Daniel, for the record, I agree.
Any discussion about that?
Warren Hensman, for the record, I was going to agree with my other colleagues.
Scotty Down, for the record, I would agree. I think that it's outlined very well in the staff report. I don't have anything different to say than the conclusion they came to. So we'd be calling for a motion to affirm, modify, or negate all three violations.
Patty Lofgren, public member. I move we agree.
Thank you.
Michelle Duncan, I'll second.
We're voting on a motion to affirm the moral fitness violations as presented. Chair Nownie.
Aye.
Member Sarek.
Aye.
Member Daniel.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood.
Aye.
And Member Willetts. Motion carried.
We will now be discussing taking action or no action. And we'd be looking for a motion to take action or no action. Scotty Downing for the record. I make a motion, we take action.
Cameron Litz, I'll second.
We're voting on a motion to take action. Chair Nowling.
Aye.
Member Sarek.
Aye.
Member Daniel.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood.
Aye.
And Member Willetts.
Aye.
Thank you.
We now have discussion on the ineligibility period, and we are looking at a lifetime ineligibility period max because of the dishonesty.
Michelle Duncan, for the record, I'll move to a lifetime.
Mark Daniel, for the record, I agree. Second.
Okay, could we have a little bit of discussion about that? Some reasons why you're picking
Oh.
lifetime? Thank you.
I think the egregiousness of the dishonesty and in particular, of being dishonest from the initial contact with the victim through the entire investigation, making, an overt effort of, trying to mess with the field sobriety tests, not being cooperative with the investigation to try to make the officer do a search warrant, refusing the FSTs, all of those, whether it be intentional acts or intentional omissions of information, lead to the dishonesty in particular, as well as the misconduct of just committing the DUI in the first place, all the aggravating factors of the child, the BAC level, the time of day. I think that covers most of it.
Scotty Downing for the record. Thank you, Sheriff. I agree with everything you said.
And Mark Daniel, for the record, I'll just add on top of what Sheriff Duncan said. As a fully trained police officer in this state, especially employed by the Oregon State Police, I believe that person has received plenty of training in regards to DUIs, DUI investigation, and above all, had a duty to know better and a duty to do better. And so I fully support Sheriff Duncan's assertion.
Warren Hansen for the record, just to share also, I would add that her experience is extremely problematic, several years on the job. And I just wanted to make sure I got that in as well.
Thank you, sir. So we'll go back a little bit. We had a motion and a second, I believe, already for a lifetime ban. And if there's no more discussion, we can move forward to the vote.
We're voting on a motion to impose a lifetime ineligibility period. Chair Nowling.
Aye.
For Sarek.
Aye.
For Daniel.
Aye.
Member Duncan.
Aye.
For Hensman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood.
Aye.
And Member Willetts.
Aye.
Motion carries.
Which would we like to do next? Or find either agency updates or are you ready, Jenna? You're ready. Okay, so we're going to move on to the proposed rule changes for OAR, a whole bunch of them.
Thank you. Jennifer Howell for the record. So agenda item number 5, the proposed rule changes. I'll go through the full rule number once on the record and then thereafter just refer to the last remaining digits as we go through each one. So these are Administrative Rule 259-008-0005. Well, I'll just abbreviate them all. They all start with 259-008. So 0290, 0300, 0310, 320, 330, 340, and 400. So this collection of administrative rules set the standards for moral fitness and moral fitness violations and the policies and procedures that the agency follows in reviewing cases and the policy committees follow when the cases are presented to you and then moved on to the board for final approval. So these are coming to you after a lengthy review by the Criminal Justice Moral Fitness Work Group that first started in September of 2003. They reviewed the current moral fitness standards and those procedures so that they could discuss potential improvements or affirm existing standards. And so all of this has been prepared for you in these draft administrative rule changes. So before I move on, I wanted to take a moment to thank the Police Policy Committee member representatives We had Chair Nowning was a representative, Member Wood, Member Daniel, as well as Member Brandenburg at the time, who's now termed off of PPC, I believe. We also had police representation from Sergeant Greg Armenta, Chief Ty Hamlin, and Chief Jim Coleman. Just a moment to thank our representatives from the police discipline on the committee. You had several attachments, and those were to help facilitate the process. Attachment A provided a side-by-side table of the definitions of the moral fitness violations that are used in these discretionary cases. We wanted to be able to show you side-by-side what the current definition is and what the amended definition would be, so you'd have those. Attachment B is the proposed rule change language shown in the revised text, and that's where I'm going to go through most of the process today, is through attachment B. It shows the additions that are shown in bold and underlined and the deletions that are with strike-through language. And then because I know that that can be complex and difficult to read, we also provided attachment C, which is just a final draft of all of the rule changes without any of the revision markings, so that if those were helpful, they were a resource to you. I'm going to go through the overview and the process, but please feel free to stop and ask questions and have discussion at any time. Thank you. All right, so beginning in attachment B on page 1, we have Administrative Rule 259-008-0005 for definitions. And what you'll see in the definition rule, we've taken several of the explanatory interpretations that are found in the current rules under 300 and 310, as well as the definitions for the moral fitness violations, and we've transferred them to this definitions rule. What that will do later on is in the policy rules, make a cleaner reading. It will take out some of that extra language, and then it will put concepts that have been duplicated in other rules into one location. So that's why the change to move those over to the definitions rule. The first rule, aggravating circumstance, that was transferred. There were no substantive changes to that. Moving on to page 2, you'll see amendments to the definition of a criminal disposition. DPSST is recommending changes to the criminal disposition definition to include a suspended sentence and a deferred prosecution agreement, which are additional disposition outcomes that may not require an entered plea of guilt or a finding of guilt by a court. We've also reformatted the definition into a list, which provides an easier way to do the punctuation, and it makes it more readable. On page 3, there's a new definition that's proposed. This is number 14, discharged. This is adding additional interpretation that focuses on the manner of separation from employment and what is not included as a discharge. It helps DPSST staff determine which cases would be mandatory cases under the discharge for cause standard, as well, or which cases would be discretionary cases that would come to the policy committee. The four cause portions of the definition remain in Rule 300 with the discharge for cause mandatory. We'll see that language later on. Definition 15 for discriminatory conduct is transferring the definition that's been found in the moral fitness violations for misconduct and gross misconduct. We did not make changes to that definition, just transferred it. 16 is the definition for dishonesty. Dishonesty is used for both the pre-employment cases that are heard by the applicant review committee, as well as the discretionary cases that come before you as a policy committee. So they use the same definition. It's been transferred, and there are some minor amendments for clarity and application. Number 21 is gross misconduct. This is the second moral fitness violation for the pre-employment standard that the applicant review committee sees. And this was a transfer without significant change. But number 22 is the new definition for the term harm, because the definition for gross misconduct and the definition for misconduct and the definition for misuse of authority all use the term harm as a part of that language. So it was recommended that we adopt a definition for what harm includes, and you'll see that listed on page 4. Physical injury as defined in ORS 161.015. Emotional distress such as anguish, grief, fright, humiliation, or fury resulting from the conduct under review, loss of or damage to a person's property, or loss of a person's rights. Number 24, the ineligibility period. This was the transfer of the interpretation. Page 5, the definition of misconduct. This was transferring that definition and then also providing it in list format, again, for better punctuation and readability and application. We did make changes to the reference to the inefficient operations of the agency. That has been reformatted into conduct that disrupts and negatively affects the operation of any agency. So separating that away from the harm that's caused to individuals and property and so on and so forth. Definition number 32, misuse of authority. Again, the transfer of the moral fitness violation definition, and it does have revisions for readability and projecting hopefully a clearer intent of what it actually means for misuse of authority. Mitigating circumstance, again, transfer of that interpretation from the previous rule without significant change. And there were no other changes to the definitions. Was there any discussion that you all wanted to have about definitions before I move on to the pre-employment standards? It will be okay to go back at any time. All right. On page 9, Rule 290, the denial of public safety professional certifications for pre-employment criminal dispositions. So these are the cases that go to the applicant review committee. These are individuals who are hired, who have never worked in public safety before, but they have a criminal disposition in their past that has to be reviewed before they can become certified. There were just some clarifying changes made there at the beginning of the rule. You'll see here, as well as throughout, that we've included at the beginning there of section 3, the application for training, denying the application for training. We've inserted that throughout administrative rule going forward, as you'll see. And that is because that is part of our statutory authority, and we just had not represented it in the administrative rule before. So that's just a technical change that you'll see multiple times throughout, and I won't have to point to it again. I do want to put a marker down for the second part of section 3. Section 3 is outlining the mandatory grounds for denying certification. It would also be denying training to these individuals who are applicants. Section 3 does maintain that the mandatory disqualifying convictions that are listed in Rule 300 still apply to the pre-employment convictions in this proposed rule change. But you'll see the exception that's been added there creates a process to consider a limited exception through a waiver, which I will explain a little bit further on when we get to section 12, where it outlines what the waiver criteria and process are. On page 10, item number 5, the changes there, removing the carve out for DUI diversions, where the DUI is the only charge and it's successfully dismissed or diverted. We have this here in the pre-employment standard, as well as in the current discretionary standard that the cases have, and the work group reviewed that and determined that it should, recommended that it be removed in both cases. This recognizes that even though the DUI has successfully been diverted, there's still the authority to take action based on the conduct that occurred, the arrest, the criminal disposition. And those actions, that conduct can still include the dishonesty, misconduct, and misuse of authority or gross misconduct for the pre-employment folks. In section 7 and 8, we're addressing administrative closures for the applicant review committee. Section 7 is acknowledging or giving DPSST staff the ability to close a case internally without additional review if it's been determined that the case was opened in error or the individual is now deceased. Section 8 is creating an administrative closure review process similar to what you all follow here in the policy committees for the applicant review committee. The applicant review committee currently receives notification of closures that staff have completed, but they don't do that same review process where you consider and then vote to approve those administrative closures. And this will create that process for them. And it will follow the same guidelines that you all have. If they approve it, then it's closed. And if it's not approved, then it would go back to them at a later meeting for a case. Okay. Section 11 on page 11, we're talking about how the applicant review committee reviews the case. I just wanted to acknowledge that the changes here are a relocation of what was left after we took out the definition interpretations for aggravating circumstance, mitigating circumstance, and ineligibility period. So it's moving that language forward into the process, maintaining that the applicant review committee in all cases considers specific mitigating circumstances, and then again, relocating what their ineligibility range is. So there were no changes to those processes, just a new location for them in the administrative rule. So that takes us to section 12, which is that consideration of a waiver of the denial for a mandatory conviction. Okay. So first, I wanted to just briefly identify that mandatory denial includes or applies to felony convictions, convictions involving drugs, involving domestic violence, or abuse of a child, a conviction for a bias or hate crime, or convictions that require registration as a sex offender. So those are the current mandatory standards. If anyone has a conviction for that, it requires denial or revocation, and that is a permanent lifetime disqualifier without consideration for any aggravating or mitigating circumstances. So the question that was posed to the work group is whether or not that should apply to someone whose conviction is a pre-employment conviction, so it occurred before they were ever employed in public safety. And through discussion, it was thought that it would be we prepared the record. You have before you a concept of a waiver. And the waiver is very limited and specific. So again, the conviction happened before they were in public safety. It is limited to with regard to the felony convictions that are not person felonies. And then it would allow for waiver in consideration of a conviction that is for a controlled substance, but only for the use or possession. So if it were for the manufacturer, delivery, sale, those would still remain mandatory. Person felonies would still remain mandatory. So looking at two very specific criteria or window for consideration. Additionally, 10 years would have had to have passed since the date that the applicant completed all of their court-ordered obligations. So their sentence, their any parole or probation, or any other supervision. The request for waiver would go to the applicant review committee for consideration. If they approved it, the individual would then continue the process for training and certification. If they denied it, then it would revert back to that permanent lifetime disqualification. The last thing that I wanted to add to that is that because it's the applicant review committee rule, the individual has to have been hired by a law enforcement agency in order for the waiver to even be requested. So we wouldn't be looking at anyone applying on their own. It would be an individual who's been hired by an agency. And I'd be happy to answer any questions. Great. Thank you. So the next administrative rule is 25900800300. These are the grounds for denying or revoking and suspending certifications for individuals who are currently employed. Again, looking at section 2, the mandatory denial or revocation. I already mentioned the mandatory convictions are for felony convictions, convictions involving drugs, domestic violence, abuse of a child, bias or hate crime, or a sex offender. There are some small changes that have been made throughout. When you look at B and the convictions involving drugs, we're adding language that distinguishes the DUI, the driving under the influence of intoxicants, where it is specifically, that is the only conviction. So if there were additional convictions that involved the use or possession of drugs, then it could become the mandatory. But if it's only for a conviction for a DUI, the DUI would remain discretionary, which follows under most of our current processes. The changes that you see in C, D, E, and F are technical changes that align the administrative rule to the rule language that's used in the Oregon Revised Statutes. Item G is a new addition. This is an addition for stalking. And the SST recommends including stalking convictions as a mandatory disqualifier, not only based on the type of conduct, but also in consideration for the impact that it has on the person's ability to own or possess a firearm. It was made specific to the crime itself. When we first talked in the work group about it, it was broadly any crime involving, using the same language that's applied for the drug offenses and the domestic violence offenses. But that was determined to be too broad. So this is very narrowly scoped to be exactly the crime as it's defined in the statute. So now that takes us to section H at the bottom of 14, and then going over to 15, and this is the discharge for cause standard, which is another form of the mandatory denial or revocation. When you look to the additions you see for G, H, and I, again, these are adding the discharge for cause standard as it's outlined in in Oregon Revised Statute for police officers. And then J is maintaining what we currently have, the discrimination, discharge for cause for discrimination, but just referring back to the definition that we use for discriminatory conduct. This acknowledges that I and J may have some overlap, but could still fall into separate categories, as well as the fact that these rules apply to all public safety professional certifications, so including corrections and parole and probation and telecommunication. And I might not apply to those disciplines, but J would apply to all of them. Okay. So 3, the discretionary standards, the cases that come before you all as the policy committee. Again, here at the beginning, you see the changes that show the transfer of the definitions for moral fitness violations. When you turn to page 16, and we're looking at section B outlines the reasons why DPSST opens the case to present to the committee. So traditionally, those have been when there is a criminal disposition or based on the conduct related to that arrest or citation. The conduct that was in line with their separation from employment, if they violated the student standards of conduct and were dismissed from the academy, and falsification, and then our blanket statement of conduct received there in G. So what we're looking to do is add section C, which would recognize conduct related to a finding of contempt of court, violation of an extreme risk protection order, violation of a restraining order, or violation of a stalking protection order. So if DPSST received information that those violations occurred, then that would be cause to open a case, collect records, and then if there were findings of moral fitness, to the committee for review and consideration.
Can I ask a question on that? Is that specific to like a conviction of those, or is that just an arrest?
This would allow for it, because it's conduct focused and not specific to an arrest. I don't have those. Do you have a better explanation of that, Marie?
I mean, as it's phrased, right, it doesn't require a conviction. And part of the reason, Marie Atwood for the record, my apologies. Part of the reason why this was a topic to include is because these violations, technically speaking, they're not convictions legally, they're violations, right? And so a person might be engaging in violating a restraining order routinely, and it would never hit this committee's radar because it didn't fit within the categories of things we could review. So normally we would probably only get notice of these if they were connected to some other crime. So this is broadening the scope of what the committee can review, but because it's phrased as conduct relating to a finding, it wouldn't necessarily be a conviction requirement, but the court or some fact-finding body would have had to make that finding for it to reach our consideration in the first place. Is that?
Yes,
okay.
yes. Sam Willis for the record. Thank you very much.
So the next, I want to take you to section 6, which is the emergency suspension language. It's on page 17. The department, the current language is very brief and states that DPSST must issue an emergency suspension order immediately suspending certification when the committee or the board or the executive committee finds that there's a serious danger to public health and safety. So the recommendation before you expands emergency suspension to an action that happens even before it would come to a committee for review. And this is to acknowledge that there are times when an individual commits an egregious crime, and it will take some time before that criminal process can go through the process before it can come to the committee or for DPSST to take action. But there's this knowledge of this egregious crime and this egregious conduct, and on its public record space, it looks like this person is employed and certified, while the public knows through media that this egregious crime has occurred. So what section A does is it would allow the department to issue an emergency suspension order, immediately suspending the certification when the individual has been charged with a crime that, if convicted, would require revocation under 2A. So 2A is that mandatory denial or revocation for the felony convictions. So these would be charges of a felony. When the work group reviewed this concept, they recommended that these potential emergency suspension orders be reviewed by a body to create that timely review process. It would be the executive committee of the board, and that executive committee of the board is made up of each of the committee chairs from the police policy committee, corrections policy committee, telecommunications, fire, and the security policy committee, and then the chair of the board as well. So that executive committee would review records that were available at the time to determine if there's a serious risk to public health or safety. And then the emergency suspension order would, once issued, go into effect immediately. The individual would be prohibited from performing the duties of their public safety office, and that would remain in effect either until withdrawn or the case is resolved through a closure or revocation. Without any questions, then I'll move on to Administrative Rule 310. 310 is the review of a professional standards case. Again, the deleted language there in 4 is the removal of that administrative closure for the DUIs that are dismissed, as previously stated. Section 4, again, as previously stated, DPSST's ability to close a case when opened in error or when the officer is deceased. The changes that you see in 5, 6, and 9 are process changes, process clarification changes. That would take us to section 10 on page 20. Just a quick explanation of the large insertion there for the big A, B, C, and D. This is adding an interpretation of a phrase that is found in Oregon Revised Statute, which says that the policy committee and the relevant discipline and the board shall review the discretionary cases. So this is really just for providing that interpretation of what who is the relevant policy committee, the relevant discipline. When we get to the changes there at the bottom of the page on 20 and B, again, you're seeing the result of consolidating the rule after transferring out the interpretations for aggravating, mitigating, and ineligibility period. But I want to look specifically at page 21 and where we've listed there what the ineligibility period ranges are for dishonesty, misuse of authority, misconduct, and misconduct that includes discriminatory conduct. So right now, the current ineligibility periods are 3 years to 10 years for misuse of authority and for misconduct alone, and then 3 years to lifetime for dishonesty or misconduct that includes the discriminatory conduct. And the work group reviewed both parts, the minimum and the maximum. And you have a recommendation to lower the minimum range from 3 years to 0. So that would begin at 0 days. And then to increase the maximums for misuse of authority and misconduct from 10 up to 20. And this basically just recognizes that there have been a variety of cases throughout the years where perhaps 3 years was too harsh for that case, but there's still the need to take action on the moral fitness violations, as well as some cases where 10 years had been found to be too lenient. So those changes are there for consideration.
Cotting for the record, is there any specifics they pointed to other than just it seemed too lenient? I'm a little worried going, into the future that draws in just a lot more dynamics that might be happening in here when you have sustained finding, and based off of how we're feeling in that particular moment, that we're going to drop it potentially to 0. when in past, consistent, outcomes have been 3 years. So I understand 3 years might seem harsh, but I also, I'm a little worried about going to 0. Because I personally, in my short time here, have seen cases that are not 100% consistent. And it's based on, presentation in the room, personal feelings, it's all this stuff that's subjective that's coming into some of this. And I think at times it's good to have some framework. Like, hey, this occurred. We all believe it occurred. This is the minimum, price tag for that. That's just discussion. I don't know if anyone, I'm just a little concerned that just invites a lot more subjective outcomes by this committee.
Warren Hensman for the record. I appreciate what Superintendent Cotting said. And as I reviewed the work, the robust work that was done, there's a lot of specificity and clarification that will support chiefs and decision-making in the future regarding hiring of personnel. And I would agree. I think that having a defined time, whether it be 1 or 2 years, could be more productive in decision-making.
Scotty Downing for the record. I was on this committee, and so I think I can speak to it. There's a lot of discussion about this, and there is the one-off cases where it is someone's career in their life where 0 days is appropriate, but that you don't have the option. And so I think if our committees are being thoughtful and, trying to apply equal times to somewhat equal cases, but each case is unique. And there have, even since I've been on the board the last 4 years or on this police policy committee the last 4 or 5 years, we've had cases where 0 days was probably appropriate in what we wanted to do and we just couldn't. And I think that's a disservice to that individual case. And I think that's what this committee talked a lot about, is there are the one-off cases. And hopefully we're thoughtful enough if it deserves time, we give it time. And so I think that's why we landed on 0 days.
Michelle Duncan for the record. In saying that, I can think of a recent case that we had about a report that was whether they turned it in or not turned it in. And in that case, there was also like some brain issues going on where I think we all agreed that like a suspension of certification would not be appropriate, even though the act itself was technically dishonest. So I agree with you that there are those one-off cases, but on the other side of the fence, I also agree that the framework is nice to have, so we don't get too far outside the boundaries.
And Cotting, just continuing the discussion, I think in those cases that we can all remember, we've chosen to take no action. That's how we've handled that.
Mm-hmm.
We're in a case that may not fit a 3-year suspension. We've had an off ramp prior to getting to that. That's how we've handled that.
Scott Downing for the record, but then you risk saying we're not taking action on this case, but we have a very similar case that we took action on because we thought we would be okay in, the number of doing a 3-year, even though they're very similar. Like I said, each case has to stand on its own, and each case has its own aggravating and mitigating factors. And I think the committee has been pretty thoughtful about those factors in the time I've been here. And, to your point of that case, I'm familiar with. Like there is a violation. We don't want to suspend this person for 3 years, so we have to take no action. Or the next person may also have the exact same violation, and we're like, we're fine because we don't have this extra mitigating factor, and so we're fine to take action. And I think that makes it more likely that we would be inconsistent as opposed to saying we are going to take action. We're just not going to. Either the time has passed where the date that it would start has already passed, and so we're like, we've already essentially been suspended for amount of time. And so we're going to go 0 more days, essentially. I don't know if that makes any sense or not.
Livingston for the record, all of what all of you are saying makes sense and is definitely pertinent to the conversation. Maybe instead of saying 0 days, because 0 days does seem like actually not taking action. And since we have that option to say that, what if we just lowered it to 1 year? So then if you're taking action, you're doing something that's a lot less, instead of saying 0, which is, if we want to say 0, then why don't we just say we're not going to take any action instead of 0? Like if there's some level of, if action, there's actually action, which would be the 1 year, and maybe just lower it to 1 year instead of 0.
Mark Daniel for the record, if memory serves me, as we've looked at a number of these and as we said in the committee, to kind of batted this around and went back and forth, going back to that 1 year standard, we all know how long it takes some of these cases to make it through to policy committee. Although staff's been doing a great job of trying to get caught up, it's still taking a significant amount of time. And so we don't have a time served option. And I know that in several cases that has been kind of a point of discussion, that, we could, given the new rewrite, take action. And could make it, if you will, time served, and give them the opportunity, especially under significant mitigating circumstances, the option to enter the career or move forward. And I think that was some of the intent and why it was worded the way that it was.
Livingston, for the record, can we change it to verbiage like you just said, time served versus a number? Because that could vary. It could be 5 months, it could be 2 years, it could be all over the board.
Jennifer Howell for the record. We don't in every case have a scenario of time served.
Right.
That may be specific to employment, or it may be specific to a period of separation from employment. So time served would be a difficult thing to capture in the administrative rule. What I wanted to provide as part of your consideration is that the opportunity to take action and recommending action. So if it's to be a revocation, means that that certification gets revoked and that certification goes away, and that individual, if you looked at all of the circumstances and either found mitigating circumstances or found that there was already a period of separation from employment that as a result of the employer's actions because of that criminal disposition or whatever conduct, the certification becomes revoked. It's permanently revoked. The individual has to go through all of the processes to reapply for certification, a new certification. And then depending upon how much time has passed, that may include additional training. But that certification action happens and that goes onto their record. And so you still have the action portion of it while being able to have the discretion to then say how much time has to pass before they can re-enter the profession by expanding it to the 0 days from the minimum. So there were times when the committees were faced with a decision of we must do it for at least 3 years or we can't do it at all. And the changing the minimum will allow you to set a time frame in which you can take action, but have more discretion on what that outcome is afterwards.
Scotty Downing for the record, the committee had a lot of conversation about the same things. It's not surprising that this was not a whim decision on 0 days. There was a lot of conversation about it.
Cotting for the record, I'll just add, I don't know that I can support, 0 days to maximum of a lifetime on misconduct that includes discriminatory conduct. I think we're in an environment where we're constantly trying to find these lesser outcomes. And I appreciate that and I understand that, but there are certain standards and lines that need to be held. And I think that sends a a hard message, no matter how remorseful one might be for that conduct.
Michelle Duncan for the record. I mean, going down that road of argument, I think you could say the same for dishonesty or misuse of authority, really. I would agree that I have some hardship, like I can see lowering it from the 3 years, that's too harsh. But if we're taking action on any of those but then coming back with a 0-day suspension, I know there's these one-offs. But I don't think that that's any different than taking no action in the first place.
Connie, for the record, I'll just add that I think this committee is going to land appropriately in each of these cases. And earlier discussion, different timelines were thrown out. And maybe we could discuss, you know, if we don't feel comfortable collectively with 0, is there a year and a half, 2 years? Where is that line? And would we recommend a change?
Scott Youngberg, I think 0 means 0 more than has already happened. I think with the practical matter with the committee would be, how long has this person already essentially been serving? As was brought up before, action has happened. To the committee, police policy committee, getting the case, action has happened. And where I see this is, well, this person has already been essentially serving a suspension because of all the actions that have happened leading up. And the committee then would decide 0 more days, as opposed to, boy, they've this long time that they've essentially been serving their suspended period. By all practical purposes, the committee didn't make that decision and the board didn't make that decision, but someone made that decision on their career. And now the board is saying, okay, that's enough. I don't think that I can't imagine a case where it comes up, we find there's violations. There hasn't been this time served and we say 0 days. I don't see a scenario where that happens. I think the times it's come up is we've struggled with the fact that there's already been this time person has been serving essentially a suspension of their certification by all practical purposes. They have been working as a police officer. And so, well, not working as a police officer, may still be getting paid. But, so that's where I see the 0 days is 0 more days of what's already essentially.
Livingston for the record, and I certainly haven't been on the committee as long as a lot of you in here, but I have seen cases where they are actively working as a police officer and they've come in. So they are currently working, they're not suspended, and they've been working for like a year and a half while they were waiting to come in here, which I always felt like, that felt awkward to me, just being truthful that they're in here and if we say that, then they no longer work tomorrow when they're actively working. So there has been a couple cases where we have seen that they've actively worked.
And, you know, Connie, for the record, to further the flips of that conversations, we've seen where agencies have taken a hard line and terminated employment, and we're saying no action.
Yeah.
So we've seen it both ways. And then I would also say on the date of time served, that's procedural. That's not a date we're setting. That is set by the agency based off of specific things that are occurring. So we've had these cases that get to us and we ask what's the date? When did this take effect? And we're trying to vet out on this 3-year, where do they land? Because we're all cognizant of all the things that are happening to this individual. I will just go back to my personal take on this is that there are still lines in this profession, and this is removing those to 0, in my opinion.
Michelle Duncan for the record, and maybe I'm wrong, but even this one, a lot of when we take action, it goes back to when the incident occurred, which is, and in some of those, and I think we had one last meeting where they were still actively doing, I don't even know how it works. If we decide to take action and we say, okay, this wasn't that egregious, but we're going to give them 3 months, and they've been revoked, but how does it look for the agency that they've been employed that whole time? I don't, I mean, and that's a current issue, it would be as well, but especially if we do it 0 days, it shows that they've had a revocation for 0 days, but then their agency has never stopped employing them in that capacity. I don't know.
So Marie Atwood, for the record, to reiterate what Jennifer was mentioning earlier, if we take action, if the committee takes action, the revocation is in place and that person still at a baseline has to go through the process of getting a new certification. Their existing one is gone. So what an agency decides to do at the time that person becomes revoked in that moment, you know, may vary agency by agency, but there would at least be a memorialization that this committee revoked their licensure based on the facts that were found. And in some of the conversation at both the work group level, and we presented these to the corrections policy committee just last week. I think the problem that was presented that led to this as a proposal was, as has been discussed, there's 3 phases, right? There's the factual findings, and that includes the aggravating and mitigating. Then there's the taking action, which is essentially this committee's ability to render a verdict, you know, on what these facts mean, what they should mean for this person. And then there's essentially the sentencing, which is the eligibility phase. And so we kept hearing these examples of cases where facts included so much mitigating information, but the ineligibility criteria were so limited that committees felt like they were forced to sort of fudge their action, you know, mess with the verdict to reach the right outcome. And so this doesn't take away the ability to enforce those really substantial outcomes for substantial cases. It just gives that leeway for the 0 to 3 year cases where someone might present very legitimate, substantial mitigating facts to reach a resolution that you're satisfied with that doesn't require you to fudge what the taking action phase entails.
For additional comment, you know, I go back to right, wrong, or different. Oregonians passed ballot measure 11. And there are certain aspects where there's mandatory minimums. So I obviously support the group's decision here, but I'm against 0.
Marie Atwood, again, just one more comment, because this was also substantial amount of discussion at the CPC meeting last week. What we told them was that if there are particular proposals, either that are discussed today or solutions or ideas that come to you later, this doesn't have to be the end of the line on the discussion. We can come back to the committee before we formally propose the finalized rules for their implementation, if ideas are floated around that we can come up and draft and offer to the group.
With this, so Scott and Ann, for the record, are we done with this part of the discussion? At least not enough.
Would you want us to return back with possibilities if any drafts are done between now and our next meeting?
Michelle Duncan, for the record, I would agree with the superintendent that I would like to see something that doesn't include 0 days.
Lisa, for the record, I agree.
Yeah, go ahead.
Okay, all right. So that pretty much concludes review of 310 and the review of a professional standards case. The remaining changes that you see throughout that are just further technical clarifications. That would take us to Rule 320. It's on page 23 of attachment B. And Just very quickly, in section 2, DPSST is adding language that recognizes the emergency suspension. In section 5, clarifying revisions for interpretation and application of the start date of the ineligibility period. Not changing what those start dates are, but hopefully providing something that's easier to read and apply. As well as in 6, again, not changing the intent of the eligibility to reapply, but hopefully providing it in a more plain language version of the rule. In 330, on page 25, there were no work group discussion points related to this process of surrendering certifications, but we've included a technical amendment there. In 340, again, no work group discussion points, just another minor edit recognizing processes relating to the denial of training, better alignment with statutory language. Okay, so that takes us to Rule 400, which is DPSST's review of the complaints that are submitted to DPSST. This rule change is presented as a rewrite, and the addition of definitions and the rewrite of sections 2 through 5 are intended to provide improved readability and more process information for members of the public who are reviewing the administrative rule. Sections 4 and 5, DPSST continues to defer investigation of complaints to the employing agency. The changes to the agency response requirements are based on recommendations that are found in the 2021 Secretary of State audit. The audit findings recommended that DPSST require agencies to include a brief synopsis of what they did with the complaints that were forwarded by DPSST to that agency. The Secretary of State audit recommendation includes the suggestion that DPSST collect whether there was an investigation as a result of the complaints, whether the underlying allegations were sustained, and whether any discipline was imposed. And the work group reviewed that and recommended that DPSST implement those changes. I do want to state there that it would be looking for information about whether those things occurred, not necessarily a full report of the details. So we wouldn't be asking you to tell us what discipline was imposed, just whether or not discipline was imposed, perhaps which allegations were sustained, but not necessarily the full underlying investigation. We're not asking for that to be resubmitted back to DPSST, just collecting those data points and whether or not those things occurred. Section 6 maintains DPSST discretionary ability to review complaints under specified circumstances. The current rule already has these circumstances in place. So when an employing agency is non-responsive on a jurisdictional complaint, when the subject of the complaint is not employed, or when the subject of the complaint is an elected official. Section 7 updates the process whereby DPSST would collect at the front end documentation and records related to the complaint before determining whether that complaint needed to go to a policy committee for further disposition. Section 8 clarifies that DPSST would have discretionary authority to close the complaint if the review of the mitigation, the documentation, and the records shows that there isn't substantial evidence of a violation. And 9 and 10 would update the committee process to follow the same steps for a discretionary professional standards case. So acknowledging that DPSST would now be collecting all of the information before ever going to the policy committee in the first place. At the point in time in which it's determined that it needs to go to the policy committee, it could just move forward as a case for your review and action instead of going as a, here's a complaint, what do we do? Do we investigate or not? And then coming back around again. So it's supposed to improve the process.
I mean, quick question, was it, the prior rules, was it 90 days for an agency to respond?
The current rule does not include the timeline for response. We just have that outlined in the letter that's submitted to the agency. And Cindy, will you tell me if it's 30 or 60?
It's 60 days.
60 days per the letter that we send with the complaint to the agency requesting acknowledgement. The current process is to request acknowledgement that the complaint was received and handled in the manner that the agency deemed fit.
Now that we're asking for the finding, do you anticipate receiving, the agency having that commonly within 90 days? That's going to be a tight turnaround.
Certainly. And to that, it also includes the caveat that if the employing agency notifies DPSST that additional time is needed, that 90 days could be extended. So we do want to recognize that there are due process requirements that are followed on the employer side. It's just a matter of maintaining that communication line, that the complaint has been forwarded to the employing agency and that the employing agency is receiving it and processing it. So there would not be any, so if it came to the 90 days and it had been communicated that additional time is needed, that it hasn't made it through its resolution and its due process, then it would just continue to remain open and we wouldn't have a report yet.
Michelle Duncan for the record.
Mhm.
Is this, just to clarify, is this strictly like oral fitness certification things? Because I've seen a lot of DPSST complaints and they run the gamut of, just some of the conduct is he didn't take my call and take a report. And so I'm a little bit leery of this section for some of those reasons that, especially trying to give, having to give findings. We may find in it that there's a policy violation for our agency, but it has nothing to do with certification standards. But now I'm having to give you a finding when typically, employment records and disciplinary records are confidential, but as soon as I give them to you, they're not.
Thank you. Yes, so Jennifer held for the record. And so there is that distinction between the jurisdictional and non-jurisdictional. And if we look to the definition of jurisdictional, it would be a complaint where the allegations, if proven, would lead that objectively reasonable person to believe that the employment training or certification standards have been violated. And so in that reporting back to DPSST, so we're going to forward all complaints to the employer. If it's not jurisdictional, we'll say this is not a jurisdictional, it doesn't involve DPSST standards, moral fitness. We're just sending it to you for your information processes. The other form would be, this is a jurisdictional one, and per the administrative rule, it requires your response. And that's where we've outlined the information, but again, leaning more towards the data points, not necessarily what all of your findings were, what all your disciplines were, just whether or not the complaints triggered any of those.
So I guess taking it down that road further is, say it's a jurisdictional one that the allegation initially is a something that would be a moral fitness standard. But through the investigation that absolutely was not true, but they did violate, maybe a driving policy or something else. Is there a duty to report back to you discipline regarding that, even though it wouldn't be a moral fitness standard? Because again, my concern is that then that now is a public record.
To further complicate that, Connie, for the record, we do see individuals that will start, agencies may not like the response, then they come here
Exactly.
and they come somewhere else and they just keep going, right? And so then the agency may have come to a, no basis, or some minor policy violation was sustained, but now it's something more potentially. So just want to think that through.
Yeah, because if you're asking me to give you whether I made discipline on a moral fitness standard, that's different to me than if I do if I investigate something. And I think we've all, as agency heads, have seen like these outlandish claims, and you go and you find none of that is even close. But I did find this. And I just don't know that that should be under the umbrella of DPSST certification.
So this is Marie Atwood for the record. If we're gonna be considering alternative drafting, so I'm looking at section 5 on page 20. That describes what the written response from the agency should look like. So assuming just for the purposes of conversation, if this were in kind of checkbox form, and there's boxes you can check that would answer the questions pertaining to these required data points. So whether the allegations made in the complaint have been reviewed, that could just be a yes, no. Whether the complaint results in an investigation could be a yes, no. And then this section, whether any of the allegations in the complaint were substantiated. So the conversation right now sounds like there could be cases where there are both moral fitness type allegations and just policy or procedural violation type allegations. If that section were amended to say whether any of the moral fitness allegations in the complaint were substantiated, would that alleviate some of the concern? That way it would carve out these sort of like internal sanction processes, personnel issues that don't need to reach DPSST's radar.
I mean, I believe that that would be the case, yes.
Okay.
If we just like make it very clear that we're only talking about those things where certification would.
Right, exactly.
That's what we have to report back to you. Because that's what we have a duty to report anyway, right?
And Cotting, can I confirm that non-jurisdictional would be policy level type stuff that you might know is a problem for the agency, but not moral fitness
Correct.
related? So I think if it defines what we have to report back on, I think that gets us there.
Same for the record. I want to echo Vice Chair Cotting's concern and Chair Duncan's concern. What if it was just because on section number 3, it says the department determines the complaint is non-jurisdictional, the complaint will be closed. What if there's a checkbox that says this is non-jurisdictional? And then you just close it, comes back to you and you close it immediately. Is that something that's doable? Idea?
Thank you, Jennifer Held, for the record. At this point, DPSST is making a determination before sending the complaint out, whether or not, if the complaint were proven, would the contents of the information that we receive be something that could be a moral fitness violation? Sure. If it resulted in a criminal disposition or a separation of employment by the agency. So at this particular point, procedurally, DPSST is forwarding the complaint. It's still being handled by the employer, and it doesn't become a professional standards case for DPSST unless there's that separation of employment. So
Essentially, if it's a non-jurisdictional allegation, Marie Atwood for the record, if when we receive the complaint, we can tell on its face, even if it's true, it's not within our umbrella, you wouldn't have to be responsive to us at all.
Yeah, same with the record. Yeah, I think I got that part. I'm just kind of building off of Sheriff Duncan's comment. If there's a checkbox that says it's non-jurisdictional, we investigated it, we determined that there was something, but it's non-jurisdictional. It's back to you. You just close it, I guess, to make it simpler.
Sure. Michelle Duncan for the record, along those lines, but I actually would change that, is that we would just tell you, like, I shouldn't be telling you whether it's non-jurisdictional or jurisdictional. I just tell you it's not just jurisdictional. Like, I don't want to get into a thing where agencies are now reporting whether we're taking action on non-jurisdictional things or whether we found something that was non-jurisdictional.
Thank you. That was exactly where I was going with that.
That's what I figured.
I just want to make sure that I understand for the record that the concern is on the reporting back of whether any of the allegations in the complaint were sustained. And then whether or not those findings resulted in disciplinary action.
Michelle Duncan for the record, maybe to clarify, is if any of the jurisdictional complaints were sustained.
And that already exists in the parent language that's found in 5, because we're only talking about reporting back on jurisdictional complaints.
Correct, but again, that way it's clarifying that what I'm reporting back to you is only on the jurisdictional thing. That there may be findings on other things. Where right now it kind of almost reads to me that it's if any allegations in the complaint are, because a lot of times these allegations, they're covering 10 different things.
Okay.
It's not just, they may say that there's things that are jurisdictional and non-jurisdictional. So I think it's more of a thing that when I report back as an agency, that I'm reporting back to you that there were no jurisdictional findings or discipline.
Okay, I understand.
Does that make sense?
Yes, 5 things are listed. Only one of them
Yes.
would be considered a potential violation of DPSST standards. The other 4 just happen to be there. So is that something that we,
Issues that we
right,
don't need.
is that something that we procedurally identify before we send it to the agency? Or we just send the whole thing, says there's something that's.
Right,
Okay,
if there's
all right.
anything that would be a hook for us, we should.
Okay, okay. Okay, I understand the comment.
Livingston for the record. I think both the sheriff and Marie mentioned that is just probably an adjustment to B that really spells out that what's in the written response back to you is only related to the jurisdictional information and leaving the rest of it blank, like I'm not even going to talk about it.
Okay.
Also Livingston for the record, just one more thing on the 90 days. I know it says on here that you have to do it within 90 days, unless, we let you know that it's going to take longer. I've done a lot of these cases through the years and any that would land under jurisdictional, I can barely think of any that would have happened or been completed in less than 90 days. Like it's not even, a lot of them will have criminal elements to it, which then we won't even proceed with the personnel investigation. Like that is going to be like, so then are you just going to keep pinging us over and over and over again for like a year and a half as it's, you know what I mean? Like I'm trying to figure out when you say 90 days and then how does that work after that? When we say, hey, we don't have it in 90 days, which is pretty much almost going to be right 95% of the time. I think that you're just going to run into this back and forth, back and forth, back and forth for a long period of time on a lot of the cases that are actually jurisdictional, because they take a long time to do. They could be out on leave, they could a myriad of things, go out on some long-term protected leave, they're criminally charged, like there's a lot of things that go into it.
Michelle Duncan for the record on that note, is it something that we could change it to reflect what's in the police officer bill of rights as far as you have 6 months to complete an investigation barring these things? That way it's kind of in line with what we have to do anyway. I don't know if that would be a solution. Because I agree, if it's 90 days, you're talking a lot of busy work back and forth because you're going to ask me where it is. I'm going to tell you we're still not there. And it just takes time for both agencies.
Connie, I would maybe just stick to acknowledge receipt, and then you're going to hear from us when you hear from us.
Yeah.
And just trust that when it's done, it's going to make its way over here. And it could be years.
Yeah.
Thank you. Any other questions or comments about the complaint rule?
Connie, I'd just say what Ms. Atwood said as far as clarifying that 5 definition of 5, I think that works. Mind repeating how you phrase that?
Right, so as it reads now, Marie Atwood for the record, it reads that the agency would be responding to us on the question of whether any of the allegations in the complaint were substantiated by a finding. And so if a complaint has 10 allegations and only 2 are jurisdictional, a more kind of appropriate response requirement would be whether any jurisdictional complaints or allegations in the complaint were substantiated by finding, or whether any moral fitness allegations in the complaint were substantiated by finding, to remove performance-based issues and stuff that doesn't need to be reported back to us.
I mean, I think that gets us much closer. I do think there's room for interpretation there. Right? An agency might be like, well, that doesn't meet the this or that standard. And you all might think it does. But I mean, that's going to exist no matter what we do here. So I think that's cool.
Yeah, and Warren Hensman for the record, I think the department will receive lots of questions from agencies on how to complete this newer portion anyway. And in the spirit of maybe the checkbox conversation regarding 90 days, maybe there's just a checkbox along with unless the employee agency notifies the department of additional time is needed, and knowing you're going to need additional time, more likely than not, you're going to check that box along with some of the other jurisdictional, non-jurisdictional kind of check boxes.
Thank you all for the discussion. I'm going to go through some more of the procedural parts and then do a quick summarization.
Chair Dunning, for the record, we've been at it for an hour and a half.
Do we need a break?
I'm thinking someone may need a break. Probably, right? Morning? Yeah. I would like to propose we take a break. 5 or 6 minutes. Okay. I can be.
I had an officer his knee replaced a month ago. He hasn't back yet.
Calling back to order. We'll call the meeting back to order, Chief.
Thank you, Chair.
About times, sir. Come on. Take it back to Jennifer.
Thank you, Jennifer Howell for the record. So we've gone through an overview of those proposed rule changes. Anytime an agency files a proposed rule change, we also are required to include a summary of a fiscal impact statement. So your memo on page 8 and 9 outlines prepared fiscal impact statements. Broadly, it acknowledges that these standards already come with a fiscal impact. Basically, if you would, a pre-existing fiscal impact. If an officer is denied or revoked, there's an impact to that individual, to their employing agency, their impacts to DPSST as far as staff processing and time and expenses such as administrative hearings and DOJ costs. So all of those things are pre-existing conditions, right? What I wanted to focus on in these statements were things that might have potential changes. So what is kind of baseline? So we highlighted 3 in your memo, and then I have a 4th one to add to the statements. So first, recognition that eliminating the automatic administrative closure of deferred cases in which the only charge is for the DUII may result in an increase of those professional standards cases, and of course, would impact some individuals who would previously have had their case closed. So there's an acknowledgement to the change there. Second, the changes to the emergency suspension authority have the potential to create a fiscal impact either for the individual, the employer, or for DPSST. If an emergency suspension order is issued, that person's prohibited from performing the duties of their public safety office, which could impact them as an employee and their employer. The third thing that's outlined is impacts based on changes to the ineligibility time periods. If there's a lower ineligibility time period, that may benefit some individuals. If there's a higher ineligibility period, that up to 20-year change that we looked at, that could have an adverse impact on that person's career and opportunities. The 4th thing that I wanted to highlight were the unknown potential fiscal impacts for the changes to the complaint process, that reporting requirement asking the agencies to report more information back to DPSST. So that will require additional work on the part of the employing agencies, as well as additional work on the part of DPSST to track that information. So there's kind of some unknown things, but areas that we thought might have some type of change. Happy to answer any questions, as well as if you had anything else that you'd like to recognize or add to those statements. Procedurally, the department was recommending approval of the proposed rule changes. And when the memo was written, it would have been written from the sense of no comments and it's ready to go forward to the board. So we've received comments from the Police Policy Committee through discussion today. We received comments from the Corrections Policy Committee through discussion, as well as from the Telecommunications Policy Committee. So what we'd be asking you for today is approval to proceed with the proposed rule change filing so that we can submit the entire package for public and constituent comments collectively, so that we can look at all of the comments in totality and make changes as appropriate to come back for additional consideration. That would be the outcome of your motion for approval and vote today, would be that we would just be filing the proposed rule changes so that we could gather all public comment and consider everything together before proceeding to permanent rule changes. And then to recapture for the record what has been discussed by the Police Policy Committee today as comments on the proposed rule changes. There were comments on the decrease of the minimum ineligibility period. So a recommendation to reconsider the 0 days as something else or to maintain it at the 3-year minimum. Comments on the complaint reporting process to clarify the obligation to report information back to DPSST when there are multiple allegations in a jurisdictional complaint, which ones only having to report back on allegations that are considered jurisdictional within that complaint, as well as either looking to amend the 90 days or provide a more a lengthier time. So just addressing, those were the things that were captured as official comments. And if you have any additional questions or comments to add to that, we can definitely add to that now.
Livingston, for the record, just for clarification, when you were talking about what we're voting for. So will we see another draft again? Or we just give our comments, you go get more comments, and then you do what you're gonna do, and then it gets approved by a different body?
I think it's safe to say that it would be most appropriate to come back to the committees to highlight all of the changes that have been made based on the committee discussions and the public comment. So that we would be committing to coming back to you in May with identifying the revisions that changed before you approve them to go to the board.
Scotty Nownie for the record. Does anyone else have any comments on anything that Jennifer discussed?
Rob Wood for the record. I want to give a huge shout out to Jennifer. She spent the last 2.5 years meticulously putting things together on every thread of our conversations, discussions. Although we only met monthly, obviously she worked a lot on this. But I would like to revisit the discussion of the length of revocation. I appreciate the concerns that were raised over the proposed 0 days. We had a assault case recently that reached a civil compromise, and we took no action when clearly a crime has been committed. And I'm thinking that we don't want to have our hands tied because we look at the period of revocation that's before us, whatever it was before, 3 years, whatever. So I like I said, I appreciate those of you who brought up the concern with 0 days. What I'd like to hear is a proposal. I heard Sheriff Duncan say 1 year. If we could do that and give Jennifer some directions to shorten up the possibility of revisiting this again next time it comes before us, I think that'd be great.
Thank you, Rob.
Jennifer, I'll just add then, if that decision point is going to be at the with DPSST, then I'll throw out 2 years just for something to ponder.
Bill Castle for the record. So this decision point won't be with us. We are here to execute the will of the policy committees and the board, just to be clear about that. What I was about to say, what you were going to say, Rob, is that's really ambiguous, 0 to 3. If you as a committee could recommend or agree on, at least have a consensus on what you would be comfortable with, that would be really helpful. So we don't come back with this draft and still have this wide open 0 to 3 that there may be disagreement on within this committee, and we have to go back again. That would be much appreciated.
Scotty Nownie for the record. I would recommend 1 year. I think someone else had said that. I think 0 has a certain connotation to it. I think 1 year is, I think for all practicality, would be very rare a case where the person has not been out of service for a year already anyway. So like I said, I think when it would actually, in practical matter, I think 1 year would probably always work. That's not just a disagreement.
I like. We vote.
Consensus?
Oh, just an additional clarification, because the point was brought up for specific moral fitness violations, looking at dishonesty and discriminatory conduct. Do you still want the 1 year to apply to those as well, or do you want to consider a different minimum for those?
Scotty Downing for the record. I would say I would leave it at 0 for misconduct not involving discriminatory conduct. It's just misconduct. I think there are probably way more cases where you would say that that potentially could be, or zero, the others would be a much bigger stretch for, to get to zero. Like, and I think 1 year would be good for those. But I wouldn't die on that hill either.
Rob Wood for the record. Thank you, Chair. I totally support that. I think we could go zero on the misconduct without discriminatory actions. And I would support 1 year. I think it's a little tough, but 1 year would be okay with me.
Patty Lofgren for the record. I was feeling pretty comfortable with zero based on some of the earlier conversations, but I think I would go with zero in the first one and 1 year on the second as well.
Michelle Duncan for the record, I would agree that just the misconduct that does not include discriminatory conduct. I still struggle with the zero. Maybe it's a 10-day or I don't know. I just don't see how doing a zero is really different from doing a no action. In my mind, we're doing the same thing and we're just calling it something different. But I can see the concept of that being less than the other three and the other three being 1 year. So I'm good on the 1 year. That other one I still struggle with.
Mark Daniel for the record. I don't think there, if we remain with the zero, that doesn't preclude the police policy committee or the board setting it in a day or 10 days or 20 days, whatever. What it does though, it makes it a little easier for us to take action. Because I've seen us on the bubble before. And that bubble, right, wrong, indifferent, and I think it's arguable, could have gone either way, and it did go either way. Especially on the no action side, because we were at a minimum of 3 years and chose to take no action because that was the alternative. At least that's where it lands in my head. But I think as a group, as a body, if we find that there is a moral fitness violation and we want to take action, then that action is going to be taken. Whether or not they're suspended, their police certification is suspended for a day or 10 years. As was stated, they still have to go through the process to reacquire that certification, which is not going to be easy.
And clarifying question, if it's a 0-day suspension, does that requirement to go through the process still exist?
Yes.
Sam Willis for the record. Chief, I'm going to agree with you on that. I think that when there's still that process in place and there's still that documentation that their certification has been revoked at some point in time for a substantiated reason. And I think that, you know, I've watched the board meetings and while this is my first meeting, I've watched and I've seen the struggle that you all have been through. And I think that that's a good kind of compromise.
Mark Daniel for the record, one more thing that I'll add, and that's, you know, once we're finished here and we're working out in our where we work and we're talking about board decisions and things like that are made. And I have seen it difficult for certain agencies or communities to make decisions based on whether there was action or no action. So I'll just add that.
Scotty Downing for the record. I appreciate all the thoughtful conversation. It makes the meetings much easier. And I think if no one leaves here happy exactly what they wanted, it's probably a really good compromise. So I'm going to be looking for a consensus on our recommendation. Oh, good.
Oh, could I summarize what I'm walking away with in this moment?
I was about ready to look for a consensus on it.
Okay,
And if that's a consensus, then you'll have a summary.
okay.
So I'm looking for a consensus on our recommendation is a 0 for misconduct without discriminatory behavior, conduct, and 1 year on the rest minimum. And so I'm looking for a consensus.
I'm Warren Henson for the record. I would agree with that also.
Got a consensus? How many is that?
Yeah.
We have 3 objections. Those are noted. Appreciate those.
And for,
That's how it works. That's how it works. America.
Chair, if I may, Jennifer, for the record. So for extra clarification, I'm walking away with the 0 application for misconduct. Not only is for misconduct without discriminatory conduct, but misconduct that doesn't have dishonesty findings and misconduct that doesn't have misuse of authority. It is just misconduct alone.
Correct.
Thank you.
And I'll give a consensus.
Is that Those thumbs up. One more.
I just meant that definition.
Yeah.
Not the 0 days.
Thank you all so much.
Thank you. Are we done with this topic?
With a motion and a vote to approve filing proposed rule changes for public comment. And any consensus on the fiscal impacts.
Okay, so we're looking for a motion and a vote.
Cotting, so moved.
Mark Daniel, second.
We're voting on a motion to approve the proposed rules changes for Oregon Administrative Rules 259008 with serial ending 0005, 0290, 0300, 0310, 0320, 0330, 0340, and 0400. Chair Downey.
Aye.
Vice Chair Cotting.
Aye.
Member Sarah.
Aye.
Member Daniel.
Aye.
Member Duncan.
Aye.
Member Huntsman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood.
Aye.
And Member Willetts. Motion carried.
We were moving on to agency updates and Castle.
Chair, thank you. Phil Castle for the record. Members of the committee. First, I want to share with you, I ran across a rule the other day that I was trying to find the historic backing of that rule, and I just couldn't find it anywhere. And it caused me to call, former board chair, it caused me to call former director of this agency. It caused me to go back and look at the record of a board that was 10 years ago. And through looking at that record of that board, I was able to discern really what the history was of this particular rule. And it was very rich discussion at the board. So what you all are doing here at these policy committees is you're making history. And it's a really important history that people will go back and review these. Maybe it's just me, but people will go back and review these for historical record. And it's really, really important. So what you did here today was really great. Like this discussion you had was so rich, really great. So just want to thank you for all that. That's really important that our records are rich, and the fact that you're restating for the record why you're voting in a particular way is super, super important. So thank you very much for doing that. All of you have very important jobs to go back to. So the time that you give to study the record and to be here in person or be here online is, we're really grateful for that. It's a very important service that you're offering. So thank you. 2, the amount of work that goes into preparation of these boards is unbelievable. So I wanted to thank the 3 ladies right here for all the work that has gone into and the work that they do every day and the professionalism. And Jennifer, you're a highlight reel today. And most days, frankly, for me, she's also spends a lot of time over at the Capitol building for us. She's our legislative liaison. So she's phenomenal. So thank you. And Marie, appreciate all your efforts as well. I'm going to keep my comments short. You've all done a lot of work today. I will tell you, DPSST is in the same situation as other state agencies right now, sort of waiting on the results of session here. We're in short session. where they'll be deciding on whether or not what agencies, if not all agencies, have a budget readjustment. So we are waiting to hear on that. We did get an economic forecast back at the beginning of February that was more positive than it was, meaning we went into the a positive instead of a negative by about 180 so million on general fund. However, that is not the landslide that will solve all problems. There still is the matter of HR1, which, or in other words, the Big Beautiful Bill, which has a tremendous impact on this state going forward over the next 5 years or so. There will be escalating impacts as fund sources like Medicaid, the match with states starts to decrease over the next 5 years. Then Oregon will have to figure out how to compensate for that lowering match rate, as we are a huge consumer of Medicaid. There are other funds too, but Medicaid is the largest impact to us. So that will impact state agency budgets as we go forward over the next many biennia. So we're all sort of waiting to see what this at the end of February here, what it looks like for all state agency budgets. F building, a lot of you know that last biennium we went to an e-board because our F building or our village had damage to it, had internal damage. The building was designed for an external wind shear. And because we have these giant doors on either side of the F building, there was an internal wind shear that was taking place, larger than we understood, and caused some serious structural damage. The F building is under repair now. We have fencing all around it right now, and we have our contractors in there working on it. They're pumping epoxy into the walls. They built an internal superstructure, adding steel beams to the walls on the inside of the structure. We've hit a little bit of a hiccup with that. The contractor got a little ahead of themselves. These beams are custom made. They're custom welded. And they put a coating over those beams called a galvanizing. Some of you may be familiar with that, but it's a weather resistance type coating. And they were not supposed to do that until the welds were inspected. So that has set us back a little bit. The contractor has owned that mistake. We were trying to find other ways we can make progress. And the reason why we're so concerned about that is that it is impacting the quality of our training. That is a huge training space for the academy. It provides context. It provides weather cover. A lot of our scenarios are based on that building space and the different venues within that. So we are having to compensate for that. So it's impacting our quality. So our desire is to get back into that building as soon as we possibly can. We officially kicked off our learning management system project. That's been on hold for a while, not knowing our budgetary limitations and whether or not we would potentially have to give those funds back. We got the word a short time ago, no, execute on it. So we are doing that. Our project manager is actually here, has been here for the last 3 days. And we are kicking off that project, and she's amazing, by the way, project manager. So we're very hopeful about that project and optimistic. We received some money to work on our deferred maintenance. DPSST is stacking up somewhere in the neighborhood of $20 million of deferred maintenance that needs to be done. We got 3.2 million of that, which don't be scared by be scared by the $20 million number. This is a 20-year-old facility now. It's starting to have 20-year-old facility problems. Air handlers on roof, boilers in the dorms, boilers down in our kitchen. The things are starting to wear out. And we're prioritizing those, using that money for anything that would impact our infrastructure. If it would shut down a building, that's what we're working on. So we're starting to execute on those now. We have a project manager who's managing all of that, and our facilities team is doing amazing work to start working on those in priority order. One of the things that will become visible to you is we are replacing our outbound gate. The gate that's outbound, if you've gone up there. It feels like it takes 3 hours for it to open up. It makes all kinds of noises it shouldn't. And we've been nursing that thing along, and gates are very, very expensive. Also, there are 2 lanes going out the outbound gate. There's not really room for 2 lanes of traffic to go out, and it creates a dangerous situation if you get cars side by side. That downhill traffic out on Almsville can be very dangerous. A lot of trucks come down that downhill road. And when you get 2 cars side by side, the one on the right can't see what's coming up that hill. So we're going to reduce that to 1 lane, and the gate will be much faster. The gate is going to be a swinging gate versus a sliding gate. So the team did a lot of research about what would be more robust, what would last the longest, what would be the easiest to maintain, and what would be the fastest opening and closing to move traffic along out there. So that's happening. We've installed new software for all of our camera systems on the Academy, which is much more user-friendly, which is much easier to store. It's using the cloud to store all of our video footage and so forth on the Academy. And we'll be investing in some new camera systems and some new AI software that'll really help us with our security here on the campus. So we're really excited about that. We're looking forward on that. I'm going to stop there and open the floor if you have any questions for me. If you don't, I will pass that over to Marie, but I'll stand by if you have any questions for me.
Okay. Marie Atwood for the record. Thank you all again for your participation today. I want to echo everything that Phil said about our role, your role. We are here to make sure that anything we enact, especially when it comes to moral fitness, is vetted and decided and supported by you and by the board. So it's a huge task. Jennifer has worked extremely diligently on. And yeah, we wouldn't be able to ensure that we are doing what this profession needs to be doing without your input. So you probably noticed that there was just 1 case on our docket today. On the one hand, I'm kind of grateful for that because it allowed us to have a pretty fruitful discussion on our administrative rules revisions. But I would say don't get used to it. We had 1 case today because, as you probably noticed, we're short-staffed in our professional standards division. We are down 1 case manager, and this particular meeting would have been her juncture for her cases to be sent to you for review. So once we hit our May session of meetings, we'll be back up to speed with our normal kind of slate and number of cases. And on that note, there are some interesting developments going on in the professional standards world as well. So not only are we going down the kind of planning and procurement pathway for our learning management system for training, we are also just impending launch of our new case management system. So we have contracted with Acadis, who does all of our training software with the training division, to also provide us case management software for professional standards cases. It's going to be a huge benefit to our team in terms of efficiency and record keeping and data tracing and tracking trends. And it should also help us be a little bit more efficient with getting materials to you, bringing cases to committees and to the board quickly, and getting through some of the backlog that's currently a pretty big challenge for us. So that launch is supposed to be happening in March. And along with our internal processes changing to become a part of the case management platform, there's going to be a couple of external processes that will be impacting you. So the first wave of changes that are external, that relate to the case management system, is going to be we're transitioning some of our forms, the F forms that we have agencies fill out to report various items to us. We're changing some of those to web form based. The 2 that are going to be our initial phase of implementation are the F28 and the F4S. And the reason why those 2 are in the first wave of this transition is because those forms are where we get these moral fitness cases. So the F28 is criminal history reporting, and F4S is separation reporting. So in order to fully incorporate our team into using case management software, the web form, being the kind of kickstarter of all of those actions, is going to also be hosted on the Acadis platform. Before we launch any of the public-facing changes, there's going to be a series of communications that go out to all of our constituents with what to expect, what it looks like, how to navigate it, all of those things. But obviously, When that happens, if there are any questions, concerns, input, or confusion, don't hesitate to reach out to me. That's what I'm here for. So hopefully that will get us a little bit closer to tackling the backlog that we've got, moving the cases through at a more rapid pace, and kind of segueing into my second topic. It'll give us information about how Oregon is doing, how our public safety professionals are doing on moral fitness over the long term, where usually it's really hard for us to track those data points because we don't keep those records centrally. So we do, however, already have to track various data points for the legislature by mandate. House Bill 4207 and 3145 from 2020 and 2021 are what mandated us to keep our public-facing sanctions database, our economic sanctions database, and they also require us to send a report to the governor's office every year with some kind of trends and data about particularly police cases involving suspension, revocation, or denial of certifications. So we just finished our report for the 2025 year and submitted that to the Capitol, 2 weeks ago? Yeah. And I wanted to go through some of those data points with you, just to give you an idea of where things were at in 2025 compared to where they were at in 2024. So with this report, we track pretty broad strokes data, but if you have any particular questions, I can also send you all a copy of this report if you'd be interested in reading it or going through it with some of your staff. So for example, in totality, in 2025, DPSST issued final revocations for certification of 32 total police officer cases. This was up from 27 in 2024. So they're not humongous numbers, but we do see an upward trend. 2024 was also up from 2023's numbers. I don't necessarily take that to mean that there is more misconduct happening. I do take that to mean that our team was being pretty diligent on processing cases as quickly as we could and trying to tackle some of the COVID era back. But within those 32 denial and revocation cases, here's some of the kind of standout statistics that we noticed. 55% of the cases resulted in a voluntary surrender of certification for a lifetime. This was up from 43% in 2024. So that's a pretty big metric change. 50% of the cases were related to conduct that occurred on duty. This was up from 30% in 2024. So a 20% increase in revocation cases based on on-duty conduct. On its face, when I first heard that stat, I thought that that meant, I took that negatively. But when we dive into the economic sanctions that we also have to report on, the thing that I saw was that 68% of our economic sanction cases involved on-duty conduct, whereas in 2024, 96% of the economic sanction cases involved on-duty conduct. When I put those two stats next to each other, you know, a 20% hike in on-duty conduct for professional standards revocation versus a 30% decrease in on-duty conduct for economic sanctions, I take that to mean that agencies are going above and beyond to make sure that misconduct that occurs on duty comes to DPSST rather than handling it via economic sanction. It seems to me that there's been a shift in mentality and how agencies are approaching cases like that, sending them for professional standards review rather than just taking on-duty performance-based conduct as an easy economic sanction solution. So I see it as a positive and not as a negative that we have increased the number of cases involving on-duty behavior on professional standards side. Does that make sense to everybody?
Okay, I have one question.
Yeah.
Talking about this data, is there something parsed out to where when the conduct occurred and trends that way?
When you mean
rather than when we took action. So like if you have, because we're so far behind, 2022, we had this many cases that in 2022, this is the conduct that occurred versus 2023, 2024.
I see.
I just don't know if that is captured because I think that would be an important statistic.
Right.
Whether the conduct is actually increasing or decreasing.
Yeah, so it is not based on the date of the incident or the particular conduct the person engaged in. It's going to be based on the time that we open and receive a case and pursue it for moral fitness. And part of that's because, kind of relating back to our earlier discussion, sometimes if a person engages in misconduct on the job, there's a whole series of events that happen before DPSST can take any action. There might be a separation, an arbitration, a civil lawsuit, a reinstatement, you know, a whole bunch of stuff before we start our processes. And we trace our stats back to day one of when the event might have occurred. We trace it back to when we became involved in the case.
Yeah, just food for thought, I think.
But it's
would
a
be
good
an
metric.
important statistic and metric because, and it can happen once we close the case and DPSST takes action or not action. But still going back to that date of conduct, we can really, I think, make a determination whether conduct is increasing or decreasing.
Yeah. And that's something we should be able to track a little bit more effectively when we use the case management software, because the software is going to do a lot of this automatic tracking in a way that we currently have to do manually with like 8,000 Excel spreadsheets, which is kind of painful. Some other stats that were notable from this particular annual report compared to 2024's report. In addition to the increase in voluntary surrenders and on-duty misconduct allegations, there was an increase in lifetime ineligibility penalties. It was kind of minor increase, but 75% of the officers that were revoked in 2025 are going to be ineligible to hold certification, period, for their lifetime. This was up from 70% in 2024. The other notable change that was apparent in the statistics is that the demographic of the officers themselves is changing over time. So we keep track of how many of the officers have at least 10 or more years of experience. In 2025 report, it was 56% of the officers. This was down from 63% in 2020. So it appears that on the whole, officers are earlier in their careers when we receive our professional standards cases for 2025, as opposed to prior years. However, in terms of the total number of cases that were revoked, the level of police officer rank showed a little bit of an increase. For example, in 2024, there were only 3 supervisory level revocations that were issued. In 2025, there were 5 of them. There were 0 management level revocations in 2024. We had 2 last year in 2025. And we also had an executive level revocation in 2025. So a little bit of a like kind of converse looking relationship. The population as a whole seems to be earlier in their career, but our revocations have involved a little bit higher ranked officials than we had previously seen. Those are in large part the kind of substantial notable differences between our previous reports and this past year's. But as I said before, I'll send you out the full report itself so that you can dive in and analyze and ask questions as needed. That's all I have for today.
Oh, yes, go ahead.
An agency update, the board approved formation of a work group to look at the maintenance training requirements for law enforcement officers. So once certified, you have to continue ongoing maintenance training, and it's just time to take a look at what those standards are and make any recommended changes. So we'll be moving forward with establishing those and would be inviting policy committee members as well as other constituents to participate. So just an awareness that it's coming, and if you have a specific interest in serving on that work group, then let me know. Thank you.
Chair, I have one more thing. It's a question actually for a few folks sitting at the table. For Chief Hensman, for Sheriff Duncan, also Chief Daniel, are you holding any vacancies right now? Intentionally? If you don't mind answering that.
Intentionally, no, but we're definitely holding vacancies.
Okay. How many vacancies do you have, Chief?
I want to say 8. We've got some folks and backgrounds though, roughly 6.
Okay, thank you.
Certified for all my disciplines, not intentionally. And total would probably be with dispatch, corrections, and patrol, probably about 25.
Copy. Thank you. Chief?
Nothing intentional. But I have, 2 vacancies and I've not been able to hire those 2 vacancies for a significant period of time. And that's what I was chatting with Deputy Sarek about, being able to find qualified candidates moving forward.
Copy. And I know OSP already, so thank you, Chair. Appreciate it.
There's nothing else. We can adjourn the meeting. Our next Police Policy Committee meeting is May 21st, 2026 at 10 a.m. We are adjourned. Thank you.